Chapter 10 of contracts, third parties, rights and responsibilities. Still in Section 3, assignments of rights. Part 3 of that section, assignees and contests with third parties. And this part concerns contests between a transferee and a competing claimant to the asset transferred. The claimants considered are creditors of the transferor and the transferees. The transfers considered are those subject to Article 9 of the Uniform Commercial Code and not others except for some mentioned in a reference to restatement priority rules below. Part 1 below depicts a contest between two assignees of the same payment rights and indicates how Article 9 assigns priority to them. Something is said above about a contest between the assignee of an account and creditors of the assigner. Part 2 supersedes or pursues that subject. Part 1, conflicting security interests. In the main, this part concerns what restatement refers to as priority as among successive assignees of the same right from the same assigner. The paragraphs that follow paraphrase the restatement section on that subject. Section 342. Aside from that, this part deals only with priorities declared in the Uniform Commercial Code. Hence the heading conflicting security interests. Restatement priority rules. The primary restatement rule about priority is a first in time rule. If an assignment is effective, is not revocable, and is not voidable by the assigner, the assignee's right is superior to that of a subsequent assignee of the same right. That's the first in time rule. Sorry, I keep going back to what are conflicting security interests, and that's title is good enough to explain what that means. Successive assignees of the same right from the same assigner. And then the restatement priority rules, the first in time rule, which makes perfect sense, right? Somebody called shotgun. In various circumstances, the restatement reverses its first in time rule. One is that the first assignment is voidable by the subsequent assignee. Another has to do with assignments of the right represented in a writing. A writing of the type customarily accepted as a symbol or as evidence of the right. So it's voidable by a subsequent assignee and it's in writing. I'm surprised that you can reverse the first in time rule, but there you have it. An assignee of that right will outrank the recipient of a prior assignment if, without knowledge or reason to know of the prior assignment, it gives value of and obtains possession of the writing. Okay, so to reverse the first in time rule. Okay. That provision makes way for the seniority accorded to transferees who qualify as holders in due course of negotiable instruments. Okay, now I'm thinking about subordinating a mortgage, and now I understand. Other reversals of the first in time rule are likewise confined to subsequent assignees who give value and act in this way or that without knowledge. The action specified may be getting payment or getting a judgment against the obligor, or entering into a novation with the obligor. Comment C to 342 states that the subject is now largely governed by the Uniform Commercial Code. It gives instances of claims not so governed, naming wage claims, deposit accounts, and some rights under insurance policies. Okay. So its limits is that you have to give value. I have no idea what they're trying to say about without knowledge. And it has to be in writing or innovation. We're going to read a short case, U.S. Claims Inc. versus Flomenhaft and Kanata LLC from 2006. USC and the Stillwater Asset backed fund LP Stillwater has conflicting interests in assets of a New York attorney and a law firm in which he was a partner, the other defendants. So it was alleged in action that USC brought against Stillwater seeking a declaratory judgment that its interest was senior to that of Stillwater. Is that the issue? The assets in question were fees that the other defendants expected to earn in pursuing clients' personal injury claims. The other defendants had made a series of sales to USC of interest in those fees. Thereafter, they had procured a loan from Stillwater, giving as collateral all their assets. USC alleged that Stillwater knew of the interest at that time, and that the later transaction was arranged by a former representative of USC, and in fact the one who had arranged the earlier transactions. So this establishes the knowledge piece. The USC claim was a difficult one because it had never filed a financing statement respecting its interest in the fees, whereas Stillwater had done so. The primary code rule about priority in these circumstances is first to file or perfect. USC sought to overcome this difficulty by pointing to Stillwater's knowledge of USC's interests and by reference to parts of UCC 9-309. Okay, so those are the rules. In other words, the clause is as follows. The following security interests are perfected when they attach an assignment of accounts or payment intangibles which does not by itself or in conjunction with other assignments to the same assignee transfer a significant part of the assignee's outstanding accounts or payment intangibles. As to Stillwater's supposed knowledge, the court referred to the clear dictates of Article 9 that a creditor's subjective knowledge is wholly irrelevant to the question of lien priority. Contrast Section 342 of the restatement as described above. As to the automatic perfection of sales of payment intangibles, the court ruled that the fees to be earned were accounts as to which USC should have filed and not payment intangibles. Being accounts, they were not even general intangibles. As to Clause 2, the court ruled that USC had not pleaded it properly. What follows is footnote 3 of the court's opinion. Okay, as to Stillwater's supposed knowledge, the court referred to the clear dictates of Article 9 that a creditor's subjective knowledge is wholly irrelevant to the question of lien priority. As to the automatic perfection of sales of the payment intangibles, the court ruled that the fees to be earned were accounts as to which USC should have filed and not payment intangibles. Being accounts, they were not even general intangibles. So these are the holdings of the court. And again, the court's opinion provided by Davis. In any event, the court note that the clause is unlikely to aid plaintiff in its position, while noting in the plain text of the provision appear to bar its application to this case. The official comments make patently clear that the exception is not intended to apply to assigners like U.S. claims. The purpose of the clause is to save from ex post facto invalidation casual or isolated assignments which no one would think of filing. Any person who regularly takes assignments of any debtor's accounts or payment intangibles should file. UCC 9-309, 4. Plaintiff is a financial enterprise engaged in the business of purchasing attorney fee interest. Furthermore, the U.S. claims interest at issue are alleged to have totaled in excess of $3 million. It is hard to believe that a sophisticated corporation like Plaintiff would have regarded the transactions as casual, such that it failed to consider that it may be necessary to file in order to protect its interests. So this is like too material to like even excuse. Notes, questions regarding this case. The action appears to have been brought a good while after the controversy arose. What can account for USC's failure to file a financing statement in the interim? Probably a mistake. 2. Significant part. The court conceded that nothing in the plain text of UCC 9-3092 appears to bar its application to this case, but quoted a code comment in opposition to that. How is it that a comment overrides the statutory text? Possibly the comment, should file, means that prudence calls for a filing, sometimes when it may prove ultimately to be needless. Safety and soundness. That's my answer to that. I'm actually answering these new questions now. Third note, sale versus loan. Is it possible to doubt that the assignments to USC were sales, as they purported to be? The aggregate interest of USC and the fees assigned was determined by the amount it had advanced plus monthly increases, but was to diminish as fees were paid. If the expectation of a particular fee should fail, not every contingent fee materializes. The attorneys were to replace it with a fee or fees makeups equal in amount to the failing one. If that might signify loan, there was all the more reason for USC to file. So, now I'm in part 2. Assignee versus creditors of the assigner. As noted above, Article 9 of the UCC applies not only to transactions in which property is collateral for an obligation, but also as to sales of accounts and most other contractual payment rights. Article 9 refers to the right of the buyer of an account as a security interest, even though the right does not secure anything. It provides that a creditor who acquires a lien on an asset or of the debtor, typically as a result of the judicial enforcement of a claim against the debtor, is senior to in right to a security interest earlier granted by the debtor in that asset if the security interest has not been perfected. That sounds an awful lot like a rule, I guess, coming out of Article 9. This provision applies to assets of many types, including accounts. It appears along with various extensions and qualifications in UCC 9-317. The rule poses a serious threat to an assignee who fails by inadvertence or otherwise to be prompt in taking action to perfect its interest. That action is usually the filing of a financing statement, often taking the form referred to above as the UCC-1, as Section 9-317 describes. The danger, describes the danger, it is that a security interest, including the right of a buyer of an account, becomes subordinate to the rights of one who has become lien creditor before the security interest is perfected. The loss suffered as a result of subordination to a competitor's lien is limited to an amount of the claim that the lien secures, but a delay in perfecting a security interest created by an assignment or a failure to perfect it at all poses a threat more serious than subordination, avoidance of the security interest entirely. The most notable occasion of avoidance is the bankruptcy of an entity that sold the account, one who may be called the assigner for present purposes. The voidability of contracts and bankruptcies is among the most intricate aspects of a formidable body of law, one not suited to study in connection with contract law in general. A few words are in order, however, as reinforcement for some practical lessons for financiers. In a liquidation bankruptcy, a trustee is chosen to administer the assets of the estate, distributing them according to a scheme in the bankruptcy code. A bankruptcy estate comprises, with some exceptions, all the assets of the debtor, but that is not all it comprises. Trustees are equipped by the bankruptcy statute with various powers to avoid transfers of assets that the debtor has made. The effect of avoidance is to bring the asset into the estate. A trustee can augment the estate by exerting one or more of these powers and should do so as the bankruptcy code permits. A transfer that was made by a debtor in bankruptcy before the inception of the bankruptcy and that is unperfected at the time is almost invariably voidable. What is more striking, a trustee can sometimes avoid even a perfected transfer if the transfer's perfection occurred while the debtor was insolvent, giving some other circumstances. One who knows the bankruptcy code will recognize this statement as a glancing reference to a section titled Preferences. A more specific statement about the law of preferences in bankruptcy, especially germane to this chapter, that is, if a debtor has assigned an account, the trustee may be able to avoid the assignment even if it was perfected before the bankruptcy, if the assignee delayed in perfecting it for more than 30 days. A trustee may do so, however, only by establishing other facts. A notable requisite is that perfection was achieved within a specified period before the bankruptcy. The period is usually 90 days. For financiers, the taking of accounts and other contractual payment rights, the foregoing observations lead to the conclusion that they should hasten to take any steps necessary to perfect their interests. Article 9 eases that task. It allows assignees or other secured parties to file a financing statement effective with respect to a particular asset before its transfer occurs, and it gives effect to a financing statement covering assets a debtor has yet to acquire, as well as those